Thanks very much for staying with us. Now, the Deputy Speaker voting while presiding has become a major issue because of the tight vote over the electronic levy policy, which remains in limbo because of the current near split or hung parliament. Now, there's a unanimous landmark Supreme Court judgment deciding that the Deputy Speaker presiding may vote, among other things. Let's bring you some reactions that have been filtering through since that ruling on Wednesday.
And still for it, I perceive the issues are very simple still for it, because nowhere in the Constitution has any statement been made that whenever a deputy speaker presides, he uses his right to vote. Indeed, as I indicated in submissions for the court, all the circumstances under which a member of parliament loses his right to vote. But actually, it is felt as Article 104 itself. And so it is really one of controversy. It's also very important to know that in all jurisdictions around the world, whenever the Speaker of Parliament or a Deputy Speaker of Parliament is a member of Parliament, he always has the right to vote. In England, it's the same. In America, it's the same. In Australia, Canada, everywhere it's the same. In Kenya, even in Africa, Kenya, South Africa is also the same. Whenever the Speaker of Parliament or Deputy Speaker of Parliament is an MP, he never loses the right to vote. The right to vote is actually linked to the right to represent his constituency. Are we saying that on account of the person being a Deputy Speaker, he loses the right to represent his people when the major issue of national importance has arisen? I think the reason by the Supreme Court clearly is sound, is in accord with practices that jurisdictions around the world, and also clearly borne out by the letter spirit.
And this applies to forming of quorum for business as well?
Yes, because indeed the Constitution was quite clear. Whenever it seeks to exclude a member presiding, it says so clearly. So you see that for the formation for business, ordinary business in Parliament, it says the exception of the person presiding. But such exception is not made in the case of forum for decision making. So when it comes to forum for decision making, the member presiding, if is a member of Parliament, clearly will be included.
I mean, in terms of subsequent parliamentary business, I mean,
yes, I mean, those things clearly were needless and were really inspired by mischief. Because all those mischief makers should have known that the parties and traditions, whenever the person presiding a member of Parliament, that person is not included from exercising his right to vote exists. So I think those things of Parliament are really unwarranted, and we really hope that they will not be repeated again. The Supreme Court has brought clarity on the matter.
A ruling of the Supreme Court on the matter as to whether a person presiding as Speaker, consistent with Article 102 of the 1992 Constitution, which provides for the quorum, and Article 104 can exercise a vote whilst presiding. Our attention has been drawn to a very disappointing ruling of the Supreme Court of Ghana, which more or less amounts to a judicial interference in time-tested parliamentary practice and established conventions everywhere in the world, in civilized democracies, including the United Kingdom. The presiding officer's vote is discounted. So it's not for nothing that Article 102 provides that a person presiding shall have no original nor custom vote. The Supreme Court, to put it aptly, this ruling is judicial support for e-levy, nothing more. Judicial support for e-levy for a struggling economy in distress, and judicial support for the restoration of a matter that they have said is constitutional. Is repugnant to the provisions of Article 102 and 104. But what can we do? They are clothed with the mandate and authority to interpret the law. This is a travesty of parliamentary justice.
It was a voice vote, and I did not participate in the voice vote. But I insisted that I be counted as a member of parliament present to constitute the quorum before a decision was taken. Indeed, this decision affirms that position that I took. I find that very refreshing. Soon after that decision, a former Speaker of Parliament called me, and he said, I called you to congratulate you for being bold to take this decision, because that is how the frontiers of the law are expanded. Matters that have never arisen are now in the fore because of the numbers we have in the chambers. So anytime there's disagreement, as I've said already, I will interpret the rules and the law as I understand it. I encourage people who disagree with me to boldly state their position, and if need be, refer to the appropriate body like the Supreme Court to guide us. As of now, at the end of it all, we are being guided. What we have not done before, where the way was not clearly marked out by our own standing orders, have now been cleared by the Supreme Court, and I think it will help us advance our democracy and our practice in this chamber. I will just be counted as where I place my vote. There's no need for any getting up or anything. I vote here or here. Indeed, I've observed proceedings in the British Parliament and the American one. The person presiding will say, add my vote to ayes or noes. And I think that practice should suffice.
The matters involved in this thing are open and shut. They're black and white. There can be no dispute about the issues that the gentleman took to the Supreme Court. It is there for anybody who wants to see. In Articles 102, Articles 104 of the Constitution makes it absolutely clear in black and white that the deputy speakers, I'm not speaking of the speaker, I mean the deputy speakers, when they're presiding, have the right to participate in the vote of the Parliament. Our speaker is expressly not a member of the Assembly. That's why he doesn't have the right to vote. In fact, he really ought not even to participate in the deliberations of the House. He's a referee, making sure that the debate is conducted properly and that the rules of procedure, the orders of the House are complied with. That's his role. That is not the case with the deputy speakers. And that matter is transparent on the face of our Constitution. So I couldn't understand what all of this furore and controversy that was artificially generated. We're being told that the decision of the court amounts to judicial interference in the work of Parliament. I'm not quite sure that the people who are saying this have actually taken the time to read the Constitution of our country. All organs of the Ghanaian state, including me as the head of the executive, we are all subject to the teachings of the Constitution. So I'm astonished about how much public energy has been wasted, I would say so with the greatest of respect, been wasted in an area, on an issue where there is so much clarity. And I'm happy that the court, and I'm sure as you're aware, the Supreme Court, when it is declaring the meaning of the Constitution, and it does so unanimously, that is the most emphatic way in which the court can pronounce.
Thanks very much for staying with us. So you've seen that the judgment has been welcomed by some and criticized by others. Now, with the full judgment available to us all, we can now take a deep dive into all the issues therein. Let's welcome to our studio our guest. To my immediate left, Justice Abdullahi, who is a lecturer at the UPSA Faculty of Law. You're welcome. And he was also the plaintiff. Is that the correct term?
And indeed, I'm also a lawyer.
You're also a lawyer. But if you're a lecturer in law, obviously you're a lawyer.
No, it's not. It's not.
Oh, not all lecturers.
Yeah, you can be a lecturer of law,
but not
by virtue of having maybe an LLM or a PhD, or even
but
be a
not
professor.
a practitioner.
But not be a practitioner.
Okay, so he's a practicing
because you've
lawyer.
been called to the bar.
Okay.
I've been practicing for almost a decade. And
so now you're a senior lawyer.
Well, God being good. Yes.
So thank you for joining us, and we are also privileged to have the Honorable Roxanne Nelson Dapiamakbo. He's the MP for South Dai, also ranking member for the Constitutional, Legal and Parliamentary Committee in Parliament.
No.
Okay, you are just a member.
I'm just a member.
You are just a member.
Common floor member.
Okay, member, but also a practicing lawyer.
Yes.
One who is always filing stuff, private members' bills as well.
Always fighting me.
And then we also have the Honorable Obi Amwa, Deputy Minister for Local Government, also MP for Ikuapem South.
Yes.
Great, and one of the longest-serving MPs we've also had in quite a while. Also, so they are all senior lawyers. So today I'm finished because they are really.
I'm their senior.
You are their senior of their seniors. Great.
He's the senior most.
Great. So thank you all for.
It's in the descending order.
In descending order, yes. Interesting. So first, I'll start with you, Mr. Abdullahi. The judgment is out. Many have been, combing through the 29 pages. Your thoughts on the views of the Supreme Court justices?
Jiva, I need to emphasize that my views have not changed. I had the judgment yesterday like everybody else. I have been going through it. But the difference between how I would do it and how other persons do it is that others would do it either for the mischief of it, they will read through for the purpose of identifying any mischief. Others would also read it for the purposes of having political discussions and maybe throw more dirty words out there. I do it for different purposes, and I'll do it first for the possibilities of identifying anything that will be capable enough for me to explore a review application or processes, and also for the purposes of educating myself the more, and of course my students and then Ghanaians for whose reason indeed I had to go for this. I did remember I made the point clearly known from day one that I did this as a patriot, as a Ghanaian, and then as a citizen of the Republic.
Many of us didn't know you were the one who filed this.
And that was the whole beauty of it, because I didn't want the political colorization that would characterize any decision that would come out of this. We've had enough polarization, and in fact, it's actually one of the biggest reasons why I had to do this. And that is also the reason why I had to literally keep the writ from the public domain. That way, when the decision comes out, my expectation was that it would have been greeted with more acceptance and not further polarize our political discourse and the things that we are seeing today. I think in that regard, I feel, considering the positions taken by the two political parties and the two presidents, former president and the second president, is making me feel that I lost part of the reasons why I had to go to the Supreme Court. Because part of the reasons, as I said earlier, was to ensure that we did not have an MPP or an NDC sponsored or stooge going to the Supreme Court and come up with a decision that everyone would easily condemn because it was either sponsored by a political party or fronted by a person with a political affiliation to one of these political parties. This is why I had to take this matter up. And the recent outburst from the two presidents and the speaker has now also joined the fray. And you clearly could see that things are not the way I expected.
Okay, but let's put those reactions are important because it's good for a discourse or a debate. The Supreme Court determined that they were to look at 3 issues for determination: whether a deputy speaker of parliament or any other member of parliament presiding over parliament in the absence of a speaker cannot be counted as part of the members present before a decision is made. Whether or not a deputy speaker or any other member of parliament presiding over parliament in the absence of the speaker can vote or take part in the making of a decision by parliament, and then whether or not the decision taken on 30th November 2021 by the Parliament of Ghana to approve the 2022 budget was a nullity, as 138 members, excluding the person presiding, were not present in parliament before the decision was made. On the issue, I think there's been a lot of focus on the first 2, but not on the third. So hopefully we'll get to look at that. But my learning from the judgment is that Ghana practices a constitutional democracy.
Absolutely.
And the view is that standing orders and the like are enactments. They should be subject to the supreme law of the land, which is the Constitution. And to the extent that it is not, they or those aspects, those enactments become null and void, which is why the Standing Order 109.3 has been struck out. By ruling in favor of a deputy speaker presiding, being able to vote or be counted as part of the quorum, it means that the budget decision taken on that day also stands.
Absolutely.
So, based on these views put forward by the Supreme Court, it was unanimous. I understand that if you have a decision that is a bit split and you choose to go for a review, then at least you know that maybe there is a chance of turning one of the judges. But this was a 7-0 unanimous. So I'm wondering to what extent you think you'll be successful in pursuing a review.
Right, Jiva, the idea of a review is not an issue of mathematical arithmetic. I mean, it's not an issue of counting numbers. The idea of a review is purely based on the law. It's purely based on the law. And the Supreme Court is made of human beings. And I feel we have a good Supreme Court, a better Supreme Court now, with that level of humility to admit when they believe strongly, when you edge on them, and they strongly believe that indeed maybe they should have looked at certain aspects of the law or other events that could have informed them to take a decision otherwise than they actually did. Remember, I have been saying that per the Supreme Court's own decisions, that the Constitution is supposed to be, and it is, a living document. And so making any pronouncement on the Constitution, and indeed any constitutional matter, should take into consideration future occurrences. And that is how lawyers are trained. You do not take, you are not short-sighted about decisions that are taken, and you do not look at today's circumstances to make a decision, forgetting that tomorrow events could tilt other way round. And if you had anticipated those decisions, I mean those events in future, you probably would have given a different outcome of whatever decision that was made today. Now, in view of this, whenever Supreme Court or any Supreme Court is making a decision, particularly on a constitutional matter, it takes all these future occurrences into account. In my view, this particular decision did not aptly capture future occurrences, and that is quite dangerous because it may be true that other jurisdictions you have speakers who probably may vote. Indeed, in my submission to the Supreme Court, it was a deliberate decision not to bring in those issues. Of course, because the Supreme Court is indeed not even confined to the matters before it. That should be first addressed by all of us. And indeed, I have my seniors here who would confirm that. You're not confined, particularly when you're dealing with the constitutional matter, to the facts before you or to even the laws before you. The Supreme Court has the freedom to explore all other areas. And that is because they have an obligation to grow their constitution. And in taking all of us along, they look into the future to determine that indeed this decision that is being made today, remember, it's going to be the final decision or the law that all of us will abide by for the rest of our lives until something triggers a change in the outlook of the Supreme Court. And so, if we have our polarized system as exists today, and you have a person presiding over Parliament, and that person has the ability to take a decision that would favor his party of interest. Remember, we have rarely been nationalistic in our outlook, in our decisions. Rarely. We are more partisan, and few times maybe ethnic, ethnocentric in the way we decide on matters. This is what I seek to avoid. This is what I believe as a citizen. I can play that significant role with the limited resources available to me to ensure that the continuous polarization does not persist going forward. And I was hoping that the Supreme Court will be behind me in achieving this just end. That notwithstanding, this is the decision that they've come out with. If, as I've said, after exploring the decision, if I find any room to go for a review, I would not need anyone to urge me on. I would single-handedly do this fight, and I would hope that the Supreme Court may look at my reasoning and probably think other way around. But if they affirm, if I take the decision and they affirm whatever they've done now, that is what we probably would have on our hands, and we may have to work it out to the best of our interests as Ghanaians, and not to be partisan or as we've always done. I think, at all material times, we should look at Ghana first, and this is what I will continuously preach, notwithstanding all the political colorization that I'm being accused of. I see that as
you hold on
as a different
to that
issue.
one.
Well, I will
So
address-
let me bring in the Honourable Roxanne Dapia-Mokpo. Good morning to you again. So you've seen the judgment and the arguments put forward. Your thoughts? Do you also think that there's room for a review?
First of all, good morning to my brother for
I'm your
what you have done.
pure brother.
Yeah, it's,
Please remember that.
and then my senior,
Yeah, he's a senior.
both at the bar and in Parliament. And Jifa, good morning. And good morning to our viewers, especially my people in South Nine. Peki, Kwali, Kwebe, Tongo.
I would have been disappointed.
I feel sad about what has happened. And let me open my preliminary commentary on this matter with a quote from Professor Justice Aharon Barak, former president of the Israeli Court of Supreme Court. He says that a constitution is a legal test that grounds a legal norm, and it shapes the character of society and its aspirations throughout history. It establishes a nation's basic political points of view. It lays the foundation for social values, setting goals, obligations, and trends. It's designed to guide human behavior over an extended period of time, establishing the framework for enacting legislation and managing the national government. It reflects the events of the past, like Abdullahi said, lays a foundation for the present, and shapes the future.
Once again, like I said.
Yes. It is at once a philosophy, politics, society, and law, all roll into one. The unique characteristics of a constitution warrant a special interpretive approach to its interpretation, because it is a constitution we are expounding. This is according to the Chief Justice Dixon of the Canadian Supreme Court one time. Now, it further states that the task of expounding a constitution is crucially different from that of construing a statute. A statute defines present rights and obligations. It is easily enacted and easily repealed. A constitution, by contrast, is drafted with an eye to the future. Its function is to provide a continuing framework for the legitimate exercise of governmental power. End of quote. Jifa, the judgment of the court in this matter that we are confronted with scatters a lot of parliamentary democratic principles and parliamentary jurisprudence that govern, shape, and color the work of parliament and national assemblies, especially the Ghanaian one. Now, if you read the Constitution as a whole, there are about 10 to 11 provisions that point to the fact that when you are looking at the office of the speakership, and let me make the point that the speakership is not a sole proprietor occupied by one person. It is an office. It's a whole office on its own. anybody, any occupant of that office is affixed and attached with some special qualities and privileges and courtesies and duties and rights. That is why when we enter the plenary, it is only the speaker who can determine that I have a voice to speak. I can stand for a whole week throughout the proceedings of Parliament, the whole week. If I'm not recognized by the speaker, I cannot speak. And that is not the speaker walking in the foyer of Parliament. That is the speaker sitting in the black seat. When you occupy that black seat, you are faced with those duties and powers. That is why, for me, when you are elected as a member for Bekwai, and you come to Parliament, if you are elected as a member for Fomina, and you come to Parliament, and you are nominated by a group of other colleagues for purposes of being elected as the first deputy or second deputy speaker, and you consented, and for that's what the Constitution says, and you agree that you should be nominated for purposes of being elected, you are signing a further contract with the Parliament of the Republic of Ghana that when you are given the opportunity to occupy that black seat, you will be impartial, you will be non-partisan, you will be fair, and you will exhibit the ability to manage order in the chamber. And above all that, you will make sure that the business of the House is carried out in accordance with the established procedures. Jifa, the Supreme Court today is saying that when our two deputy speakers, when they leave the front bench, like they are often assigned to sit, when they leave, all of us, when they leave the common gallery, the common floor chamber, and ascend to the black seat, they have the right to participate in a voice vote. All in favor say aye, then he will shout and add his voice to the votes. And when a division is called, and he decides that the heads be counted, his head will also be counted. Jifa, the absurd consequence is that when controversial, topical, political programs are presented in Parliament, such a presiding speaker can decide. It is not for nothing also that the Constitution says those two presiding officers or deputy speakers should come from different political parties. So where they are presiding and there is a controversial matter that borders on politics, now he's been empowered to actually look at one side of the House and allow them only to debate, and he will put the question and the decision will be made.
But let me just read a portion of the judgment from page 23. And the Justice Kulendi seeks to highlight a crucial point, that members of Parliament sit in the House as elected representatives of their respective constituencies. Parliament operates on the standard principle of equal representation, or one member, one vote, which with matters decided by a majority vote. Therefore, to cause a member to forfeit their vote in Parliament merely on account of having to preside over the business of the House in the Speaker's absence would unfairly disenfranchise not only the presiding member but also their constituents. Such an interpretation would likely give rise to certain perverse outcomes and/or incentives. For example, it could lead to opportunistic absences by a speaker or one or the other deputy speakers, as an absence would mean a vote loss by the presiding member and their party. In particular, as Article 96(1)(b) of the Constitution requires that the first and second deputy speakers come from different political parties. An interpretation that deprives a presiding deputy speaker of their vote could give the rival party an unfair advantage in a sharply divided vote. And I think that is the crux of what has been happening in Parliament over the last 3 months. There's a sharply divided vote over e-levy, and there is a sense that in this instance where you have, though unusual, 2 deputy speakers, one from the majority side, the NPP, a second one who, though an independent candidate, has opted to do business with the majority side. There's a sense then that in this sharply divided vote, there could be instances of opportunistic absences by a speaker. We are not saying that's what Speaker Bagbin is doing, but this seems to be a valid argument.
Not at all. In fact, it's one of the most reprehensible portions of a judgment I've read in my life.
Because it's written as that because of the term opportunistic absences.
It's an attack on the integrity of Parliament. They are imputing improper motives to the office of the speakership. That when any of the occupants of the office of the speakership in Parliament, the speaker and his 2 deputies, when they are absent for opportunistic purposes.
You didn't say that.
No. Why?
So, it could be that.
Why would a judge use such a phrase?
He said it could lead to. He didn't say it will.
Why? Why? Look, if you say it could,
Yes.
you are imputing. It could. Why would you? Look, so why would, for instance, could I say that when a Chief Justice is absent from a panel, or even if he travels, and in his absence, the senior most acts, his absence is as a result of an opportunistic reasons.
They are not the same.
They are the same.
They are not the same.
Look, this judge could have used another phrase.
So for you take issue with the use of opportunistic
Look,
absences.
look, if you read this judgment carefully, it's an attack on Parliament and its work and its structure.
Isn't it the reality that the
it is not the reality.
No, that the near split Parliament has created a whole new environment that we need to reconsider?
Which new environment? Why, you think when the framers were drafting the Constitution, they didn't anticipate? Anybody who will say that they didn't anticipate this hasn't read the Constitution in total. In fact, they anticipate that a day will come, a party will have majority in Parliament, but won't control the executive.
No, but then they will have a speaker.
Yes, as for that, that is why they said the speaker must be a non-member. Any person fit to be a member of Parliament could be elected to be speaker.
What are the other? You land on that because Justice Abdullahi raised an issue. Honorable Obi, don't worry, I'll come to you.
It's taking 1 hour.
So no, I'm not taking 1 hour. He took some time to ask a very long question.
It's okay.
So I'm saying that the question that you just posed and the way the judge addressed the issue and the language he used saddens my heart. You cannot impute improper motive to a member of Parliament and what he does, let alone the speakership. When the speaker is absent, it is for good reasons. When the deputies are absent, it is for good reasons. No speaker can be absent from Parliament for purposes of opportunism. That is malice. That is malice. And again, the court got the facts wrong in this area. Look, if you read page 3, in narrating the facts, the court said 1, 2, 3, 4, 5. He said, the House, in the absence of the majority, with 137 members present, the Speaker put the question for approval of the 2022 budget to a voice vote.
Yes, that's what happened.
Now,
That's what happened.
Tifa, this is the court, the Supreme Court, and all our courts, they are court of record.
Yeah.
And so I am wondering on what material did the Supreme Court base this finding of fact?
Yes.
This is the votes and minutes of the 20th sitting of the 3rd meeting of Parliament, Friday, 26th of November, 2021. If we check these votes and proceedings, we had 274 members of Parliament present. I was hoping the Supreme Court would have gone ahead to define when you are present in Parliament, what does that mean? They didn't do that. So if you take the record of Parliament and the record that the court is basing one of its material finding of fact, there's an error.
The numbers are wrong.
Yes. Look, it is not for anything that the Constitution itself defines sitting of Parliament. And let me, with your permission, for me.
Yes, go
read
ahead.
that. A sitting of Parliament. One minute.
That is to form a quorum?
No.
Okay.
That's a sitting of
A
Parliament.
full sitting?
Yes.
Okay.
A sitting of Parliament includes a period during which Parliament is sitting continuously without adjournment, and a period during which it is in committee. Our standing orders further elucidated on this. In fact, they copied the definition verbatim. So it says that a sitting includes a period during which Parliament is sitting continuously without adjournment, and a period during which it is in committee. They did the good work by further going down to define what a committee is. Standing order says a committee of Parliament means a committee of the whole, a standing committee, a select committee, a special committee, or an ad hoc committee. Then it went further to define what a committee of the whole means. A committee of the whole means a committee composed of the whole body of members of Parliament. So don't let anybody tell you that when the Constitution says that a committee, it means a committee of the whole. Because the committee of the whole has been properly defined. So when it says a committee, it means committee of Parliament qua committee. Now, others have made the argument that when Speaker Gbagbin suspended proceedings temporarily after the majority walked out, it truncated proceedings. So when he reconvened, it was a new set of proceedings, but I disagree. Given the constitutional definition of sitting, there was no interruption because we are not adjourned. Indeed, courts themselves, when courts are sitting sometimes, they take a short recess. So the Supreme Court ought to have averted its mind to this critical material. Okay. At the time that the budget was rejected, Parliament had full 274 members present.
Now, I just need to ask you quickly before we move on to Honorable Bio-Amoah. You referenced something in the quote, the preamble quote you gave us about, taking into considerations issues of the present, issues of the future.
Yes.
I've heard the argument that much as this court ruling addresses a specific issue, it didn't also take into consideration some concerns, like, for instance, what would happen if at the committee level you are to break a tie when there is voting where a chairman of the committee is not required or allowed to vote. Is that a matter that is of concern? Do you foresee that in trying to stick to what this judgment says, there will be issues at the committee level that could be impacted because of this then?
Indeed, I've heard the majority leader intimate that by operation of law, because decisional laws are parts of our laws, but especially Supreme Court decisions. So by operation of law, our procedure as pertains to committee work will also be affected in the manner that you have intimated. I am tempted to agree, but again, it leads to a certain absurdity. The absurd consequence is this, and I have evidence, I'll soon demonstrate that to you. When the e-levy was referred, for instance, to the Finance Committee, and a determination was to have been made as to whether or not it was worthy of being considered under a certificate of urgency, and a vote was put, the 12 members from the minority group voted against. Mm-hmm. 12 members of the majority group voted for, minus the chairman. So it was a tie. So by the status quo, he had to cast his vote. He has the right to cast his vote. So he cast his vote. So it became a 13-12 decision to consider the bill and the certificate of urgency. What the new scenario will portend is that where at the consideration of such a very contentious bill, one member from the presiding chairman's side is absent. So you have odd numbers or even numbers, that's 24 instead of 25 in attendance with the chairman. Where a vote is to be cast, it will be 11-12, given the scenario I've given. The chairman will now inherent in the chairman will be an original vote. So you cast and it will be 12. But there will be a tie. He will now have...
There is no one else to break the tie.
No, because...
in his mind, then the chairman will have two votes.
Will have two votes.
But I do not think that...
You see,
that's quite absurd.
Exactly.
That's quite absurd.
But you believe that that could potentially happen.
That is interpretation.
No, but that's an overstretch of the interpretation.
At all.
Okay, but that's something to consider.
No, but that is the absurd consequences.
Okay, hold on,
I'm telling you.
Lawyer Abdullahi.
That's the absurd consequences. I'm suggesting that it will happen. Because Supreme Court hasn't said that the right to a casting vote is taken away. It doesn't. It doesn't evaporate.
Okay. But you see, the casting vote.
Hold on. It doesn't evaporate at all. It's still inherent in him.
Okay. All right. So
that is why it is called a casting vote. He must make a decision.
Okay. Let me bring in the Honorable Amwa.
So the point is that then he will now have the right to cast. So you have two votes inherent in him. That is the absurd consequence. And let nobody say that it's a stretch of the interpretative process. It is
Honorable Amwa, you have the floor. And I think one of the critical arguments that have come out of the ruling is that Parliament's standing orders has been struck out. There is a view that this is an interference in a time-tested parliamentary practice, and that the Supreme Court judges shouldn't have gone there. Your thoughts on that and the other issues that colleagues have raised?
Thank you so much, Jifa. Good to see you. You're doing very well. When I'm not here, I watch you, and I really like the way you're working. Good morning to my colleagues here. And I have to commend a good lawyer for taking this matter to court. Indeed, as you said, it's a landmark case, and he should be proud to be associated with this matter. For the good people of Ghana, they are more interested in how Parliament will conduct its business in a decorous manner, not this chaotic situation. And this chaotic situation has arisen because somehow, before taking the trouble to interpret the Constitution and our standing orders in our own way. And indeed, the Supreme Court is saying that they were compelled to come in because they have conflicting interpretations to the Constitution itself. And they have the authority to interpret this. That's why they even took the matter in the first place. Otherwise, they would have said that if it was purely parliamentary procedures and standing orders, then you should solve your own problem. If it's between the legislature and executive, it's a political question doctrine, so try and solve it. But they said the major issue was interpretation of the Constitution. And for that reason, they were clothed with the powers to ensure that we got this far. And as I said, the good people of Ghana should think that at least some clarity has been brought to this matter. And going forward, there should be no interpretation that should create this kind of chaos. Because if you remember, at a point, the first deputy speaker was compelled to say that in this matter, I want to bring it to the fore, even before we start, that I will vote. And by his own interpretation, he felt that if he was presiding, he couldn't vote. So he would
step aside
from
the seat.
For the seat so that he could vote. And our friends didn't agree. They wanted to snatch the seat from the podium. There was a huge scuffle. Some people were injured. And the whole world watching it was wondering what was going on. Ghana of all places. And if we could interpret it our own way and bring this chaos, then I should commend him that at least we've come this far and we should all understand it. This business of we will see how this will be implemented in the parliament and all those things should not come from people who are members of parliament.
But it's a matter that must be looked at.
No, I'll come to it.
It must be, because the examples he gives could be worrying.
I'll come to it. If, for instance, he is sitting here, Roxanne.
But I haven't said so.
Roxanne, no,
no. I'm just saying that.
No, some have said that, and he's aware. There are some of his colleagues that I could quote here, but you haven't said so. But if, for instance, Roxanne had a good fortune to be second deputy speaker, which he could easily have been.
Amen.
Which he could easily have been.
Amen.
Yes.
I'm sure he's on that path.
Which could easily have been. And then you told Roxanne that for the 4 years that you'll be staying in parliament, cumulatively, about 2 years of the 4 years or more, you couldn't vote.
You'll be presiding in the chair, so you won't
vote.
How will he explain that to his constituents?
Of course. And he may not even be returned to parliament because of that. But what I'm saying is that this is a landmark issue. We are glad that it was taken to the Supreme Court. Indeed, the Speaker of Parliament, Right Honorable Abang Babin, was looking forward to this. If you look at the Hansard of 15 February 2022, he was saying that he understands people are ready to go to court, or some have gone to court as to whether the deputy speaker can vote or cannot vote. He said these are new areas. They are becoming contentious because it's the first time that we're seeing some of these things. He will be glad. In fact, there's a full quotation here. I'm just paraphrasing what he said. That he thinks that it will enrich our democracy and that we should encourage it. That's what he said. The Hansard, 15 February 2022. I've referred you to the Hansard. Anybody can go and check. Indeed, I even saw it only yesterday and said, so Speaker said this. I went further to even check, and there was even an audio confirming that the Speaker was really looking forward to this situation. He said it was a welcoming development. That's what he said.
Purposive interpretation.
Which purposive interpretation? He said it was a welcoming development that people should go to court on this interpretation.
Not a
so, in that respect, I think that we should all be happy that this matter has gone to the highest body to interpret the Constitution for us. And they are saying that if it were your standing against a law or how you proceed in Parliament, how you do your things, we may have declined because it was like usual political question. But now we think that we should come in. And I think that is very commendable. The second thing is that if we say that the ruling is only for now, I don't agree. It's for now and the future. Indeed, we've taken some of these things for granted. I mean, just last time, MPP was 169, and whether the deputy speakers could vote or not wasn't an issue.
It didn't matter.
But Teodoro spent more time in the seat when he was deputy speaker than any time. NDC was the majority. Nobody bothered whether Teodoro.
But the truth is, at that time, there was no crucial vote. We didn't have a near-split parliament.
That is what I'm saying. That whether or not we anticipated this, now we have this situation. And the courts have come out to say that clearly, if the Constitution says that for the deputy speakers, they have to be members of parliament, then you should anticipate that when it comes to voting, they cannot be excluded. That is why Joe Osei felt that if he was presiding, and it will look absurd, he would rather wait for his colleague to vote than come and take over so that he also go and vote. Even that, our colleagues prevented it.
But Honorable, respectfully,
yes,
at the time,
yes,
it was not out of the absurdity that he took that decision. It was because the standing orders forbade him from voting.
Yes,
so
I'll come to that.
No, that message needs to be clearly stated.
I agree with you.
Thank you.
Now, as to whether our parliament is supreme or not supreme, since 1969, since our 1969 Constitution to date, that thing has been abolished.
No,
But
with
that
the-
was because
the
we had
Constitution
a
is the supreme
parliament.
document.
Because at that time we ran a parliamentary democracy.
Every organ is subject to the Constitution.
No, before then, if you look at the 1960 Constitution, it wasn't the case.
Yeah,
well.
which is
You
typical
understand?
I
of
speak of the
parliamentary
19th
democracies.
Which I speak
typical
of the Fourth Republic.
which
You
was
speak of the
typical-
Fourth Republic.
which was typical of the British Parliament. That's
Yes.
the only thing they can do is to change the amount to a woman.
Even now they are not.
You understand?
With the
So-
enactment of the Supreme Court Act.
Yes. So we should all agree that
their Supreme Court is not like our Supreme Court.
It is.
No.
So-
If you check, their Supreme Court is still the House of Lords, really, in
Yeah,
reality.
it's just a convention
Yes.
of name.
Thank you. So that's what I'm saying.
No, but they still their decisions are still subject to their
Subject to the court.
interpretation.
Okay, so
I'm on the
Honorable
floor.
Amwa. Yes, we are on the floor.
We are only helping.
Okay, but Honorable Amwa.
So one, if we agree that if Parliament should pass any law, and that law is in contravention of the Constitution, the Supreme Court can shoot down. And we have several cases, either the Act itself, or just recently even the capping of common funds.
Yes.
There was an act to that. Podo and his friend, what's the name? But their group went to the Supreme Court. Supreme Court shut down that act and said that you cannot bring capping when it comes to common fund.
But
It was an act of parliament.
But Honorable
If
Amwa,
you look
isn't
at-
the fear that if a standing order is struck out, as we've seen in this instance, we can see a gradual incursion
No.
into
Let's
standing
no,
orders
no, no,
and
no.
the way Parliament does things.
I appreciate that, Ifa, but let's understand the situation that anytime Parliament passes any law, whether a parent act or subsidiary legislation, the Supreme Court can be invited to find out whether what they did was in conformity with the Constitution. And it's been happening several times. Clement Park.
That I agree.
Clement Park went to court that the Ministry of Local Government had created electoral areas, but it's not the work of Ministry of Local Government, and Parliament had passed it. Supreme Court shut it down. There are several subsidiary legislation. I used to be chairman of subsidiary legislation, so I've taken the trouble to look at all the cases that Supreme Court had intervened, and there's a whole list. I have some of the cases here. Plenty, several situations. So
for you, there have been lots of instances where the courts
Of course.
have upheld Parliament's laws that have been enacted.
no.
Or so clear up for
What
me.
I want to say is that
It's rather the other way
what
around.
I want to say is that if my good friend Abdullah should get up in the morning, go through what Parliament has passed, whether an act or statutory legislation, and he thinks that it's in contravention of the Constitution, he can go to court. If Supreme Court finds that indeed he has a matter for them to address, they will address it and say that no, the Parliament could not have done that. Or yes, Parliament had a right to do it. I'm saying that there are several cases.
Okay, so we
So
shouldn't
when
be
it comes-
surprised. So we shouldn't be surprised.
At all. When it comes to standing orders in the hierarchy of laws, it is the third on the line. We have the Constitution itself, Acts of Parliament, and subsidiary legislation. This standing order is subsidiary legislation. And indeed, the court is not saying that we are throwing everything away. It said that particular provision that you have put there is in contravention of the provisions of the Constitution. To that extent, it is null and void. If I have used it all this time, today we are declaring that you cannot use it because it contravenes the supreme law of the land, which is the Constitution. And it shouldn't be an issue for, as far, of course, sometimes the unfortunate situation is that even for us in Parliament, some of us, we didn't take the trouble to know exactly some of these situations. Until I became chairman of subsidiary legislation, I knew subsidiary legislation, but hadn't gone deep into it. It got to a point you find a colleague member of Parliament asking you, so what is this whole business of subsidiary legislation? Indeed, let me tell you, the courts, the judiciary, brought a matter to Parliament on subsidiary legislation. The bar was not happy about it. I was invited to come and tell them what really the matter was. When I took them through all the cases, they were surprised. I said, you have not affected your mind to it, but that is the law. The law is that you, even in Parliament, if you pass the law, it's in contravention. The Supreme Court had every right to shoot it down. So people should not create the impression that...
Right, but that is right.
Yes. So people should get the impression that it's an intrusion. Intrusion, and that now we cannot operate because our standing part of our standing orders have been shut down. We cannot accept that situation because that's not what it is. And it's not the first time Supreme Court has been invited to come in, and there are several cases, as I've said. Beyond that, my brother, with all due respect, wants to say that when we go to Parliament, I enter, I go and sign, there are prayers, I take part in the proceedings, and I have to leave for whatever reason. And it's time for voting, I should be counted. No, members present and voting. Otherwise, it will be upset. I mean, I'll sit in my office, I'll watch TV, which I do, watching proceedings in Parliament. Sometimes I get interested.
You walked out.
Why do I? No, it's the same thing.
No, it is not.
Why do I?
Then you could deliberately truncate the business of Parliament.
No, it's not deliberate.
Yes.
But even if it's deliberate,
Yes, Honorable Ahmad.
if I sit in my office watching proceedings in Parliament, obviously when it's time for voting, I think I'm interested. I'll go to Parliament to be counted. I cannot sit in my office to be counted and say that in the morning I went to Parliament, so votes and proceedings had captured me. So when we put all of us together, then we form a quorum. The major issue the court had to determine was about quorum. How many do you need to conduct business, and how many do you need to vote?
But on that particular day, you all walked out of the house.
It doesn't mean anything.
In protest.
It means a lot.
It doesn't mean anything.
It
means
does.
a lot. This is not the first time people in Parliament are walking
Of
out.
course, but when it comes
Listen.
to a crucial decision that
when
needs
it
to
came
be
to
taken,
when it came to
you walked
overturning
out.
when it came to overturning the so-called rejection of the budget, they were not in Parliament. They were
They
absent.
didn't even show up at all.
Does it make any difference?
Yes,
That they
because
won't turn up at all.
you came and you put your names down.
That's what I'm saying,
They
that
didn't even show up at all.
If they had, let's say, 140 members and they had done their business, who would have cared whether I walked out or not? They had a quorum. We are saying that 137, they didn't have quorum. And for anybody to stretch that interpretation to mean that when I'm sitting at the cafeteria drinking tea, that means I'm in the house, so I should be counted. Be upset. Then you finally 10 people.
I am asking you, what does it mean to be present in Parliament?
What it means to be present in Parliament is to be in the chamber.
How?
You may be at committee. Listen, there are different situations to it. There are different situations to it. Some I go to Parliament, I'm marked present, I take part in proceedings, I have to walk to committee for committee meeting. I still see myself as having come to Parliament. But when it comes to voting,
Where do we
taking
vote?
a decision,
Where do we vote? Is it not our sitting?
in the chamber.
Is it not our sitting?
Yes, in the present.
Is it not our sitting?
Look at the constitution, please.
No, is it not our sitting?
Which sitting?
We vote at sitting. And sitting has been defined by the Constitution.
Unfortunately, Speaker Babin tried to rationalize what he's doing.
No.
Tried to,
What he's doing or
I'm talking law.
no, what I'm saying is
We vote at during
Speaker
sittings.
Babin, no, you let me talk.
You have finished talking.
No, he has not finished, please.
What I'm saying is punch you.
No, it's not
Then keep quiet and let me
It's not
talk.
punching me.
Keep quiet and let me
So
talk.
you are saying Speaker Bagbin tried to rationalize
Rationalize by saying that once you are in the presence of Parliament, then you can be counted. And I'm saying that with all due respect, it's upset because I can be in my office. I will not be counted when we are voting or taking a decision. I can be at the cafeteria or even committee meeting. How come that when we are at committee meeting, they ring a bell that everyone should come? Otherwise, people raise quorum. Yesterday, I went to Parliament, all right. Halfway, I went to my office in Parliament. And the bell was rung several times. I had to stop what I was doing and go back to Parliament because people had raised quorum. Otherwise, why wouldn't they have said that we saw Obiamwa here this morning? Or
But
we know he's in his
Honorable Obiamwa,
office.
the Honorable Dapiam Akpor raised an important example of what could happen at the committee level. You say that we should not, it's not always about looking ahead. We are dealing with what has happened now.
Yes,
but we should look at it in a holistic manner.
How come
Yes.
the differ? But I was saying that we had taken a lot of things for granted because this is the first time that we have raised that thing majority. Raised that thing because it's 137 is the independent person who has agreed to sit with us. Raise that thing. It's never happened. Even though we have come a bit close before. So a lot of things were taken for granted. As I said, any deputy speaker could sit, whether about Yodro or Jogate or Seusu, and we couldn't be bothered whether he will vote or he will not vote. Because without him,
It
there's
made no difference.
But
Because the majority had the numbers.
yes. So this decision
But
is telling us that
it's for this razor thin reason that
Yes.
the rules must be applied strictly and fairly.
this decision.
How does a person become a judge in their own court?
There's not a judge. I don't know whether he's
Justice Abdullahi.
Abdullahi. I don't know whether I heard him that he said the constitution should be amended.
Yeah.
If constitution is amended, then you see that is the law.
No, in
but
respect
but
of-
as far as we are concerned, the present situation, which the Supreme Court has interpreted, is that when you are sitting there as deputy speaker, you have a right to vote, whether you are regarded as a referee or VR or whatever.
Absolutely.
Yes.
And you see, the
but
Supreme
my
Court
point
came
is
to
that-
this decision
Yes.
having this political conundrum in mind.
So
the
just a quick
reason-
one. Why did you raise that?
They actually
Justice?
alluded to it.
Let's listen
Hold
to
on.
it.
Like,
The
why
issue
did
of
you
my
raise the
amendment
issue?
is that, see, my position is this. There's a reason, there's a purpose for which the Speaker is not a member of Parliament. And that is to ensure that he's impartial and more nationalistic looking in his decisions. Now, I have pointed out that it would be very simplistic and sometimes maybe next to irrational thinking to assume that the Speaker has no role to play in the decisions that goes on in Parliament.
So he has said it.
And so, good. And so,
He can be impartial, but he's not neutral.
good. So my point is this. I mean, take out Speaker Babin, but any other speaker. Now, if this is the role that the Speaker is supposed to play, and in his absence, we have deputies who have political interest in whatever goes on in Parliament, then it defeats the whole purpose of having an impartial person or a neutral person sitting as a member, as a speaker at the time. So my position is this. Why don't we then have all the deputies also coming outside of Parliament?
No, that would really be
This is
something
the
else.
best way to avoid the kind of situation that we find ourselves in.
let's
at
deal
this
with
moment.
what we have
And so
now.
it is the reason why I make it that recommendation that we need to have our speakers, the three of them all, coming from outside of members of Parliament. Because if the idea is that once you're a member of Parliament, you are supposed to focus on your business as a legislature, then let's have them do that business. Because this whole business of having party members as deputy speakers was for two main reasons.
All party members, MPs.
But they represent. But there's a representation of a party, and there's an effort.
Independent member.
This is an unusual situation.
It's not unusual.
So,
No,
right.
they're independent members.
You say
then-
we came to Parliament as independent
Yes,
member.
but what I mean is, we've
The
had
point here is
other,
that
for
they
instance, the
represent
time that Freddie
particular
Blay was a first deputy speaker,
Yes.
representing the CPP,
Yes.
and then you had another MP.
But we've always had
You
it
know,
so
and then there's a view that the
until this-
speaker is
When-
coming
when
from the
Batudo-
government
And you
side.
also caucus with the. With
And
the
he even
NPP.
caucused with
Yes.
them. So literally,
No, he's not a party member.
yeah, he may not be a party member, but having that kind of representation, the idea was to ensure that at every point in time, there's somebody in the house to represent, to ensure that business goes on.
Yes.
And second, also to cut down on cost.
Yes.
Because if you're having somebody to come from outside of Parliament,
That's a
it will
different
cost you a lot more.
remuneration issues.
And if you have the issues of Speaker Babin always having to
You've
travel.
taken over from you.
Because you asked me that question.
So let me
and I need to
I
address
was
that.
just
And I
Alright,
need
so
to
let me
re-emphasize.
let
I was just
Honorable
referring to
Hope
you.
finish on that point.
So it is better to
No,
have
Abla, you
this
just made
system.
a point.
You see,
Yeah.
And it's-
you won't let me
I'll
talk.
give you the last point.
And it just hit me. Speaker Gbagbe is not always traveling.
Sorry, let's withdraw that.
Yes.
Let's withdraw that. No, let's withdraw
Please.
that. Whether his absence or presence, does
Yes.
not even matter.
He
The
may
point I'm
even be
making
at
is that
home.
whether the person
Or in the office.
so that anytime you do not have a speaker, we can have full-time deputies who do not necessarily belong to any of these political parties, who may not be biased in their outlook, who may not be impartial in the way they, or would be, in the way they do things, and would, of course, put the nation.
Okay.
So-
Your
on the top
final
of the
point,
list of
Honorable
priorities.
Amwa. Then
Why
I'll
not
read
have
some
a
text
party?
messages.
No, they has to
So
come
more or
to
less.
Oh, I'll take a break and come
it has
back.
come up
No,
to me.
but you-
Oh, I'll take a break and come back, gentlemen.
More or less.
was
Okay,
a question
please
for you.
allow
We go
Honorable
to school.
Amwa. Thank you.
2 points. 2
Yes,
points.
sir.
Right.
More or less, he agrees with me that the present situation would be absurd for anybody to say that these are members of Parliament and they cannot vote. He is advocating that then the Speaker and his deputies should all be non-members of Parliament. If that's the way we want to go, fine. But as it is now, in the Constitution and as interpreted by the Supreme Court, indeed, those two persons are deputies, have every right to vote, and it could be him. As I said, I don't know why I always think that he could be a good deputy speaker. It could be him. And would he have said that?
Roxanne is a good guy.
Would he have said that? Be careful what you say.
Be
Would he
careful
have
what
said
you
that?
wish
Me, I'm good at what I do.
Would he have said that he would decline to vote? That's another thing.
the point
The
is
last point.
Hey,
Last point.
you
Yes.
giving him one.
It's about.
He's actually an
you
hour.
come back.
But you're interrupting me, and you're enjoying what I'm saying.
No.
The last point is
So
the
your last point.
opportunistic absence.
The opportunistic absence.
I mean, I put it there, and you've hit the thing right. If for any reason there's this tight situation, and then you have a speaker with a certain motive, I'm not saying
Okay,
this
but
now.
I think you don't need to go on that explanation because Honorable Roxanne Dapiamoko says it doesn't impugn
No,
just
no, no, no,
a
no, no.
speaker. It impugns all of you
Trust
because it
is
means any
good.
of you could do
Jiva,
that.
Trust is good. Control is better. We don't put people there just to trust them. The system should check what is done. So if for any reason a speaker decides that anytime I'm away, the deputy speaker who doesn't belong to my side doesn't have a vote and the vote is tight and then they will lose the vote, why not? Even if that's not his motive, people will goad him on that. Oh, today why don't you report sick or absent so that the deputy speaker is deprived of his vote? So you're saying that we are guarding against opportunistic absences, and what is wrong with that?
All right,
We
let
are
me
passing
read
laws.
some
No,
text.
I want to respond to this.
Specific.
No.
We haven't It's a
finished,
very-
though.
No,
I
oh,
haven't
you are done.
finished.
You said that's the last
I
one.
haven't finished.
Because I have to
No,
read
you
text.
see,
Can you hold? Okay,
yes,
quickly.
no, come back to
it's
you.
very important.
Okay.
You see,
It's let him come back.
the speaker doesn't determine business of the house.
But if
It's
it's
a
not
committee.
available,
Wait, there's a committee
if it's not available,
which is called the business committee, and they determine business of the house. We have leader of government business. So whether or not the speaker is present, it's immaterial. No, you see, they were attempted. There's a certain deliberate attempt to malign Speaker Gbagbe.
nobody has mentioned
You
Speaker
have.
Mbabi here.
I'm saying that
that
in the absence of
all
Speaker
speakers.
Gbagbe, government could conduct any
It
business
covers
it
all
deems fit.
speakers. I'm not referring to Speaker Babin.
So
I'm
to
saying
say
they
that
are
his
guarding.
absence could be for opportunistic reasons.
You are misquoting me.
It's so.
You
No,
are
I'm
misquoting
quoting
me.
the court.
He's-
It's so.
you are
But the court didn't say
Okay,
that.
but
The court said so.
The court
The
didn't
court
say so.
suggested so.
Bagbin.
The court mentioned
saying-
He
Babin.
mentioned Speaker
I'm
Bagbin.
saying, as we speak, e-levy has not been considered. If they were minded, they could consider e-levy in Bagbin's absence. Why are they not doing that? Why do they think that?
Is that your problem now?
No, it's a problem.
You rejected
Because
the budget
No,
with 137.
No, it's-
No,
you
but
wanted
now
to-
the
you
budget-
came back-
now
you
by
came
the
back to
Supreme-
restore it.
Now, by the Supreme Court
You
ruling,
came
the
back to
budget is
restore it.
accepted.
You came
But
back
the
to restore
point
it.
is, why don't
But
you then bring the policy so that there's
No,
a vote
the
on
point
it?
I'm making
You're
is
already
that-
having
the
problem
point I'm
with
making is
quorum in
that
the House.
the court fell into error of interpretation when they said.
So far, you haven't pointed anyone.
I pointed
because
it out.
that's your 2740 that you said.
Yes.
It's bogus.
It's not bogus.
It's bogus.
It's not
I've
bogus.
displayed
You
here.
I've asked you, what does it mean to be present in Parliament?
And I'm saying
Okay,
that
gentlemen.
present in Parliament in the chamber.
Sitting has been defined. What
In the
does
chamber.
it mean to be
Otherwise,
sitting?
otherwise there's no need
We
for
tell
quorum.
you sittings are sittings.
Okay,
Otherwise,
so
there's
let
no
me
need
take
for
Sitting has
quorum.
been defined.
Okay, so
If
let
you
me take
deliberately
these
walk
text
out on a
messages
decision,
and
that
then
is
we
your
come
matter.
back. Masawadu Hamza Jr. writes, in fact, reading portions of the ruling from the Supreme Court makes me feel sad because it makes me feel like one person is making a decision for all of us. This one from Akwesi Motown. Please, the Supreme Court has shut down one of the principles of natural justice, which is no man is a judge in his own cause. This one from Aziz in Wa. The judgment is a bit disappointing. This is misinterpretation. A.U. Farouk from Tamale North. Good morning. In fact, the ruling by the Supreme Court on the voting rights of deputy speakers seems to support what the minority says, that it's judicial support for e-levy. But no matter what, the e-levy will not see the light of day. Kweku from La Paz. There are three arms of government. If the Supreme Court can make laws for Parliament, can Parliament also do same if they are unhappy with the Supreme Court? Well, they can't, because the Supreme Court is the apex court of the land. Their interpretation of the Supreme Court becomes law, and any other law is subject to the Constitution. This one from This one has no name. It says, good morning, Jifa. You cannot eat your cake and have it. If you take the speaker's position, which allows you to accept, reject, direct the House, why should you still want to vote? That's from Moses Nkwanta, Oti region. And those were some of your messages. There are a lot more. I'll bring them back. Let's take a quick break and we'll come back and wrap up on the issues relating to this. Thank you for staying with us. Some of you have still been sending your messages. Let me read them because they have some bearing on the next part of the discussion. This one says, the Supreme Court in their conclusion in the last paragraph of page 23 and the last paragraph of page 24 of their judgment had this to say. So he goes on to read, but I think the important part is the last bit where he says, it must be emphasized, however, that the procedural or operational rules to practicalize the protection of this constitutional right in a member presiding in the absence of a speaker and his or her deputy to represent his or her constituents in the vote and decision are matters within the exclusive domain of Parliament itself. Parliament may achieve this by amending its orders or adopting parliamentary practices to give effect to this constitutional imperative. This one from Prince Henry Koforia says, since the president is defending the decision by the Supreme Court, he should also know that the NDC minority in Parliament will also defend the Constitution and standing orders of Parliament whenever the controversial e-levy is introduced to the House. This one from Garba Akunsi from Tamale. He says, Jifa, who in Ghana doesn't know that Speaker Bagbin has been biased against the ruling government? After this court ruling, let's wait and see whether Speaker Bagbin will continue to be in Parliament at the right time. I'll urge the NDC to challenge the ruling if they so wish and not attack the integrity of the Supreme Court. And those are some important thoughts. So let me come to you. Should Parliament amend its standing orders then to give, true meaning to what has been laid out by the ruling?
That would be a positive decision to take to reflect the current circumstances. But unfortunately, not unfortunately, but truth is, as it stands now, the standing orders stand amended by the declaration.
Automatically,
it stands amended to the extent of the order 109.3. So you do not need to take any positive steps to have it taken out because it's already automatically gone. Perhaps what they may probably do will be to print a new one without
a new book, without
that provision.
We are doing new standing orders with several amendments to the standing orders.
So that's it to that extent. Having said that, as I was saying earlier, I think we need to push this message across very well, strongly, and the constitutional amendment to ensure that we do get deputy speakers from outside of members of Parliament, and possibly we have to relook at the whole idea of how the appointments of speaker and deputy speakers are even.
But we know how the speaker is appointed.
No. I'm saying that we should relook at the whole.
From both the speaker to the deputy speakers.
Because really, Eva, as I said, you see, all these accusations are coming up today because of the mode of appointment, or the selection or election.
That is in particular Speaker Bagbin.
No, with all speakers. What you've noticed is that.
I wonder why. I don't. In my experience, looking at all that has happened, we've seen Speaker Lajete, we've seen Speaker Annan, we've seen, the female speaker, her name Banfuado. We've seen Bejina Sechi Hughes. I think what we have now gives us more flexibility. Because I remember when Speaker Lajete had finished his first term, it was Speaker Bagbin who nominated him once again. But the majority side wanted someone else. It was put to a vote and Bejina Sechi Hughes was chosen. So I'm not sure if looking at all of that again is necessary. If anything, it may stifle us because then there might not be opportunities like we saw how Speaker Bagbin became speaker. The minority side managed to get people from the majority side to back them. Next time, it could be the other way around.
Jifa, once again, and that is because...
Certainly, if they're even coming outside Parliament, we will have to vote.
Yes.
Obviously.
We have to vote in
And,
Parliament.
and there will be subtle backings by sides.
No, that is because you are looking at it from
A partisan point of view.
or the voting aspect of it. The kind of amendment I'm looking at here, I'm envisaging, is the sort that would even take away the whole appointment procedure from outside of parliaments. We could have the Parliamentary Service Board, for instance, to take this decision. That would be a completely...
Parliamentary board?
No.
Okay, just hold on. Let him make the point and then you can respond.
That's why I said we could.
It's a suggestion.
Exactly.
Good.
I said we could. My point is that we shouldn't leave it to the partisan politics of things to get a speaker. Because remember...
Or
There's
deputy
something-
speaker.
Or deputy speaker.
My good friend, the challenge sometimes some of us would have is that we let partisanship be connoted as something negative or evil. There's nothing wrong with partisanship. I mean, that's what democracy is all about. And that's what our constitution, everything is about. We go to parliament, we vote sometimes on party lines. It's everywhere. Democracy everywhere in the world. So let's be careful the way we use the word partisanship as if it's negative.
Well, it has always been negative in our part of the jurisdiction.
No.
It's mostly been negative.
But
so,
I think the
that is where...
Okay, but I think
that-
the
that-
critical...
negative.
It's mostly been negative.
So you see us as negative people.
Okay, so Honorable Dapiamapo, what do you make of this suggestion? We should have all our speakers from outside the House?
We can't have an independent institution taking these decisions.
May I, if I may, have a few rebuttals?
Okay, go ahead.
Number one,
Yes.
it is not correct to suggest that the deputy speakers, as we have them now, being members of parliament, don't have voting rights. That is not the issue. The issue has been when they are occupying
the
that
seat
black
of-
seat, what happens? You see, in interpretation, marginal no's are very important. If you go to our constitution, if you go to Article 297A, implied power, under A it says that the 297B, where a power is conferred or a duty is imposed, the power may be exercised and the duty shall be performed from time to time as occasion requires. A, the power to appoint a person to hold or to act in an office in the public service shall include the power to confirm appointment, exercise disciplinary control, and all that. Now, if you go to 295(2)A, a reference to the holder of an office by the term designating his office shall, unless the context otherwise requires, be construed as including a reference to a person for the time being lawfully acting in or performing the functions of that office. With this provision, Parliament then defined Speaker or Mr. Speaker to include member presiding at a sitting. So when you put all this together, there's a certain purpose. It is when the deputies are sent to that black seat that they are right to vote. Yeah, the seat is black.
No, but you can't be describing it as black.
There are only 3 black seats in the chamber: the speakers, then the leaders.
Yes.
Okay, so for
It's okay, but the black seat, it's okay.
the
Black seat is fine.
Yes,
It's a
or
nice.
the green seat, or the green seat.
Why is it
The green seat.
Because Speaker
You want
belongs
it blue, so the green seat. When you are sent to
Well,
that
you're
green
talking
seat,
about deputy speakers.
no,
So
you see,
it will be
but
blue.
I'm saying we are talking law. Their positions have been defined in law. You can't escape that. It is the definition that is ascribing certain powers and duties to them. When you sit in that green seat or black seat, you assume certain powers. You act as if you are. That is why you can determine that me, member from Southern, I won't have a voice to speak. So don't let the argument be said that when you are a member and you become a deputy speaker, your voting rights evaporate.
No, they don't evaporate. The
they
concern is
only
when they are presiding.
Yes, they are only suspended when you preside for very, very good reasons. You must exhibit a sense of impartiality.
If
you must be neutral. You must be non-partisan. Otherwise, if you have an unscrupulous deputy speaker, he can decide that only Obiamwa and his generals and lieutenants will have the debate and they will put the question and vote. No. In fact, they can do that till eternity.
Doesn't work that.
I'm telling you, it can happen.
But it's also possible that if, in going by what you say,
yes,
and you continue to have a minority side that maybe are out in full force,
yes,
and a majority side, yes, that are encumbered by numbers. As we know, there's a current MP, the MP for Dom Kwabenya, who is currently unavailable. There's another MP, we are told, who also hasn't been available for a while. The minority side could then be unscrupulous and seek to stifle anything that comes
That is
to
why
the house.
Consensus building is key.
But who is not building consensus?
You are not building consensus.
In what way?
You cannot be seeking to building consensus when you are arguing this way. You understand me?
If my interpretation of the Constitution is different from
no,
yours.
Yes,
I don't think it's about that particular one.
And the arbiter says that.
No,
but the arbiter's decision is leading to a certain absurdity. The arbiter,
that is your opinion.
Yes,
it's because
the arbiter.
As a lawyer, it's your opinion.
Exactly.
Okay, well,
because let me finish.
Let me finish. Yes.
Because the arbiter appears to me to be oblivious of the peculiar nuances of Parliament.
So you help him go for review.
You understand? That's one. That's one. That's one. Then two.
You can also help.
The decision that.
How would I help you?
Or the decision that.
For review to
the decision that order 109 sub 3
our constitutional rule
is struck down for
decision.
No.
Why?
It is struck down.
It's a perfect decision.
On grounds that it is void. It is void ab initio. It's so troubling. It is actually a lifting from the Constitution. The court hasn't demonstrated how this offended the Constitution. And let me demonstrate.
Which part?
Let me demonstrate.
You always
Honorable Abba, let him read and then address. Please,
no, I don't read the Constitution.
110.
Yes, I know that.
Go to Article 110.
Now read 1093 of the standing orders.
Yes, which has been struck down.
Yes. A deputy speaker or any other member presiding shall not retain his original vote while presiding. How does this offend the Constitution and where? Because I have quoted 295.
But
hold on.
No, I know, but the judgment referred to the principle of
which
one
principle?
man, one vote.
Which principle?
Based on what is in our law.
See,
and
that is the error. Hold on, I understand.
Deny that person that vote.
You've asked that, so I get it. How does he offend it? Because that principle is not applicable. Their voting rights is not taken away. It's only suspended briefly. They themselves, the court itself, have gone ahead to distinguish what a quorum for decision means and what a non-decision quorum means.
Based on the Constitution.
Which Constitution?
Based on the
exactly.
Have you not read the judgment?
Oh, I have read the judgment.
Yes.
So
they were meticulous.
Oh, please, they were not meticulous.
Okay,
you cannot say that.
So,
you cannot suggest that Parliament sits for non-decisional purposes. Hold on.
What you are saying, your constitution, they don't understand.
They don't understand. We are talking law. We are talking law.
But if a constituent of an MP does not have representation, that is an offense. No. Isn't that why they say Sal is the cardinal sin of the 8th Constitution?
It is not correct.
8th Parliament, sorry. Isn't that what
it's a very mischievous point to make. That when you represent the people of Bekwai and you become a first deputy speaker, you cease to exercise the right of representation for the people of Bekwai. It's a very mischievous point to make.
It's not mischievous.
It is, and it is not supported in law.
It's a person
because you have your voting rights intact. Because when you assume the green seat or the black seat, you assume certain powers that I don't have. In fact, you determine how even the House votes.
Good.
Who has a voice? Who doesn't have a voice? Which business to be carried or not?
So how do you explain? I mean, I know you've said that the person assumes
No,
additional
let
power,
me
but
finish
how do you explain to the constituents?
Let me finish this point.
Your time is up.
So it is not correct to say that
Your time is up.
Article Order 1093
1093
offends the Constitution. They haven't demonstrated how it offended the Constitution. When the definition for a speaker includes a deputy speaker supported by Article 295. How can anybody say that this offended when the Constitution says a speaker shall have no vote? And a deputy speaker a speaker defined includes the deputy speaker who also won't have any vote, and you say that offends the Constitution?
And that definition is in conformity with the definition in the Constitution.
Yes.
That definition.
Okay, Honorable Obiama,
That the deputy
yes.
includes.
So
the-
you cannot
the
be
substantive.
striking down a
It's the
provision
same
in the
thing that
standing
Constitution
orders.
says. So really, if you take it from that angle, it's quite difficult.
So they haven't considered the Constitution as a whole. My final point.
Oh, I thought you had finished, Honorable Dapiamako.
No, it wasn't.
Oh,
It
you're
was
not
my
in court.
second point.
Hey!
We are in court.
Okay.
Oh, you're-
Now we are talking law. This is a panel.
Press clients so that they
I'm
can-
not
Okay, so
impressing
please
clients. We are
quickly wrap
talking
up.
law.
Please quickly
Let's
wrap
talk
up
to
your
the
point so that I can
Yes.
take Honorable
The other
Amma.
issue, the suggestion is the attempt to distinguish a decisional quorum and a non-decisional quorum. It's very important. They are suggesting that Parliament sits, or they are presuming that Parliament sits and deliberate and doesn't make a decision on occasions. Parliament make decisions all the time when we sit.
No, but I think
Hold on.
It's very important. You cannot be suggesting that when Parliament is in session, we don't come to a decision. We just talk and walk away. That's the kind of impression it sends. Even when we adopt this, that's a decision. To adopt this, we take a decision. So it is not trivial. Every decision made in Parliament is subjected to a form of a vote. So it is important that we don't interpret the Constitution this way.
Okay. Yes, Honorable Obiama.
Well,
And I
I'm
will
sure-
give Justice Abdullahi the
I'm sure
final
as
word.
lawyers, if we were to debate this matter,
We will not finish.
depending on where we stand, we will try and canvass our position, sometimes so forcefully, probably even a person watching us may not know where to stand. But the reality is that what has happened? What has happened is that there was a major debate about whether deputy speakers could vote. And I'm saying that indeed, for the first deputy speaker, he felt that he could vote by not even sitting in the chair. And he made room for that. He was prevented forcefully, violently.
Okay, but Honorable Amwa, if he steps down to cast his vote, who is presiding?
The second deputy speaker.
And then
That was arrangement.
And then when he finishes,
Listen, that
they'll
day-
swap.
no.
Is that it?
And that scenario
If
doesn't
I-
offend the
if I-
Supreme Court.
On that day, when the decision was to head count, indeed the second deputy speaker had voted. So the first deputy speaker said, "It's my turn to vote."
So they swap seats.
So he should come and they violently objected to
But
that.
doesn't that seem odd, sir?
The Constitution.
That is abuse of procedure.
That's the Constitution. Otherwise, you're saying that any time the second deputy speaker sits, his side should be in the minority.
We are not saying that, but
Yeah, that's the implication.
We are not saying that, but the
That's the
point,
implication.
but it seems quite odd. I mean, Honorable Dapiamako used abuse of procedure. I don't know. I'm not a lawyer, so I don't
It's
want to
an
get
abuse
into
of
that.
procedure.
But
It's not abuse
one
of any
person
procedure.
votes, gets down, the other person comes to sit,
In fact,
and then
And they all-
that is what amounts to an
That's what-
opportunistic change in the seat.
but look,
That is what the Supreme Court should have vetted. its
in
mind.
other jurisdictions, it's so clear. Nancy Pelosi.
Are we in that
no, but we are
jurisdiction?
not a
Are
federal
we in that
system.
jurisdiction?
No, please.
Don't we have different constitutions?
Okay, just hold on.
You
When
were
we were
targeting-
talking,
you were
I
targeting
did
when
not
you were
violently
sitting.
interject. You are violently interjecting.
Okay, Honorable Amwa, but the
What
truth
I'm saying is that
yes.
what I'm saying is that we have chosen this constitution through referendum, and the interpretation which has been given to it is that when it comes to quorum for doing business under 102 is 1/3 minus the person presiding. When it comes to voting under 104, it states clearly that at least half of all members of parliament present. It didn't say excluding the members who are speakers. He didn't say that. So if you want to interpret it, that means that either deliberately we put it in the constitution because we knew what we wanted to do, or if it's an oversight, this is the constitution we have. So to say that it's absurd because one person will vote before another person votes, it doesn't change
It has
anything.
clearly been
But
stated.
what
I've-
I've shown, but what I've shown
What you have
amounts to
refused
some
to do
abuse.
is to accept that the speaker includes the deputy speakers. That is what you are
It's
refusing
not
to do.
true.
No, but don't they enjoy special privileges?
Speaker
Ajaho.
Yes.
No, don't they enjoy
Listen,
special
no,
privileges?
no.
They are
That is
part
not,
of leadership.
Ajaho is not the law.
Please,
Ajaho is not the
please.
law.
Honorable
Let me
Dr.
talk.
Amakpo,
Let me
yes,
talk.
let's.
Speaker Do Ajaho, he was a member of parliament. He was first deputy speaker. The next term, he was nominated as speaker of parliament. He had to resign.
Yes.
If he had to resign
Yes.
for Ahiafo
Yes.
to take over.
Yes.
By virtue of the fact that the constitution says that you cannot be a speaker and belong to parliament.
Yes.
The constitution then says that the two deputies should come from parliament, one from each side or not belonging to the same party. But when it comes to quorum for doing business, they should not be counted. When it comes to voting on the resolution, half should be present.
Yes.
And nobody is saying that he cannot be part of the half. That's what happened. And then you're saying that it's absurd.
It's absurd.
The
Because
constitution,
the speaker has
the
been
constitution
defined.
is absurd.
Who is presiding?
That's what I'm saying.
Who is presiding?
It's the speaker. The
Yes.
deputy speaker is presiding.
Yes, so he's the speaker.
But the
Once you are
constitution,
in the chair, you
but
are,
the
the,
same
you are
constitution is saying
exercising
that
the powers of the
the same
speaker.
constitution is saying that
Yeah.
when it comes to resolution,
Yes.
half should be present.
Yes.
And
half of members.
Okay.
including those who are members of parliament
So just
and
to
who are
wrap
also
up,
deputy
so
speakers.
just to
No,
wrap up
who-
on,
as-
on
when you
with
are
you on
occupying that
this.
seat, you cease
So just to wrap up,
be-
because
to
at
have
9 we
voting
have
rights.
to do Sal.
Yes.
Do you foresee any further challenges? Because the minorities say that they are resolved to uphold what is time-tested parliamentary practice.
Which is
Oh,
which is because if you
Maintaining-
sometimes
maintaining the order,
Jifa,
the standing
with all due
orders.
respect, sometimes when some MPs talk, they display too much ignorance. With all due respect,
100% agree.
they display too much ignorance, and it's an embarrassment to some of us. I mean, if you don't know, ask so that people will teach you. Sometimes the way we talk, in any case, what are you saying? But you apply time tested. Why? I mean, having to
One of such ignorance is one member of parliament saying that I belong to a political party.
oh,
I
that
don't
was
have a
that
party
was a
card.
political talk.
No, that's part
It's
of the
political
ignorance.
talk.
Yes, that I bear a political party card.
No, but you
But
have
what
a
I'm
right
saying is
to
that-
No, I'm
If
not-
anybody-
No.
we
Please,
didn't
listen, some of us-
address that
That is
issue.
yeah,
Every-
another
every-
display of ignorance.
Oh, but you won't let me talk.
No,
Okay, so
Even some of us, some of
the
us,
level of ignorance.
So
I mean,
Honorable
we
Amwa.
belong to the Standing Orders Committee.
Yeah.
So you understand the
Yes,
committee.
yes.
Some of us are even advocating that this time around, when we bring the Standing Orders, we should
Yeah.
go through Article 11.7.
Yes.
This Standing Orders I'm holding.
In enacting it.
This Standing Orders I'm holding.
That's all we're
that
going to
it's not either a CR or an airline. We just adopted it in Parliament. It didn't go through the Article 11.7.
It doesn't qualify under any of the categories.
Yes.
So we are insisting that we do
You see the
proper
thing. So if you say that one provision has been thrown out, so you insist on doing your own way, then why are you in Parliament?
So
That wastes everybody's time.
So hopefully you expect that things will run smoothly. But Honorable Dapia Amakpo says things cannot run smoothly if you don't see consensus. And I think the way the e-levy has gone has demonstrated a lack of consensus with
but-
the minority side.
Or they are
thing is that-
sending
but they
Crystal
rejected,
Council,
but they rejected the budget.
Council of State.
Before they rejected the
But you
budget.
respond.
No, but by the,
Almighty budget.
no,
they
but
rejected
by
it.
the, but by
Haven't
the
you
Supreme
restored
Court ruling,
They
the
rejected-
budget
didn't
is
you
In the
upheld.
same way,
Didn't you restore it?
this whole talk, for all due respect, this whole talk, and now we have to even go and explain. If we had the numbers, we would have passed it.
Yes, but
They passed numerous things because they had the
but
numbers.
you also, but now you don't have the numbers.
Yes.
Yes,
The
sometimes
second parliamentary you pass some controversial
when we were in
bills.
opposition, I'll go. Oh, so you can come and even oh. Oh. They were just passing things. Like you can have your say, we'll have our way.
So now it's payback time. Now it's payback time.
No, it's not payback time. Yeah, I believe in consensus. It's not payback time.
Okay, so
you on the other side, you know my position and situation.
So
I believe in consensus.
Okay,
But
so let's see how
people
this goes.
should make consensus work.
All right.
You don't come representing your people, and the next moment you are throwing blows on the stage, hitting people with whatever you have. That is very embarrassing.
Okay, I think
and if this ruling would prevent it, we should thank him for it.
But when you send soldiers,
I think Parliament has apologized for that. Yes, Justice Abdullah.
Obiama should say that word. You
Yes.
have to properly thank me.
Yes.
I mean, you don't say it with the word of mouth.
So Justice, you have the file.
I'll hire you as my lawyer.
No. Send him a bill. Send him a bill.
So Justice Abdullah, you.
done.
I mean, this is going to go into the law report certainly, and we'll be quoting it with your name there. So your final point, because I know you have to use it.
Yes. Jiva, listening to my seniors and indeed colleagues here, I'm well motivated to, as I've been indicating, pursue this line of nation building furthermore, and to ensure that we bring some level of sanity in our political discourse and indeed in our democratic credentials. And I think we should all pursue some of these things in the interest of the nation, not in the interest of our political parties. I know Obiama will tell me that sometimes political interest is also good. There are indeed times that political interests coincide with national interest, but
Like now that NDC e-levy. Is it national interest or not national interest?
If you ask me, it will be a national interest.
But there was something
because there's no way I would like to pay.
But there was something I didn't ask you. One of the things which hasn't been addressed really is it upholds the budget that was approved.
Yes,
then.
indeed. This one has been the most silent of all the decisions. Nobody even talks about it. Yeah. I think we need to emphasize that if the Supreme Court had upheld my reliefs, what it would mean is that we didn't have a budget as of today. And that would have probably been very dangerous.
Would they have done that?
Well, but that was part of the relief.
Oh, yes.
That's why I said if they had.
The third relief.
That's what I'm saying. If they had upheld,
but they wouldn't have.
Well, they haven't. So it's not more. They wouldn't have.
Nuclear meltdown.
And that would have been the most dangerous thing. And nobody really has taken a look at that part of it. And so for those rejoicing, they should rejoice not because of the speaker or deputy speaker voting or not voting, because that was just possibly it's just one of the.
No, it's more paramount than even the rejection of the budget.
Maybe. No, depending on who is looking at it.
We're interpreting the constitution our own way and always fighting.
No, I agree.
Yes.
Which is why my initial comment about the judgment was that it was a very good judgment, to the extent that it brings sanity into all these whole matters going on. But that notwithstanding it, it's still problematic in a lot of ways, as I've indicated earlier, particularly when you look at it from the perspective of having a speaker, whether by way of deputy or the substantive, not being neutral and impartial in his decision making. And so if you take that out of it, I think I probably would have greatly accepted this decision. But that part, I have an issue with.
So you are still looking at it.
And all those urging me to go for a review, including Speaker Babin, I'm looking forward to an engagement with him.
They should bear your legal fees for you.
That's what I'm saying.
It takes money to be doing this.
No, but that is the office of the speaker.
Yeah.
So I'm saying that he.
the office.
So bring an invoice. Bring an invoice.
Thank you.
Bring an invoice.
Please.
To the office of the speaker.
Parliament's money to your own cause.
But this is against Parliament.
This is a national cause.
But this decision is against Parliament.
You are getting this wrong. This is a national wrong.
Against Parliament.
This is a national interest.
If you had sued Parliament.
This is a national
But
interest.
this is against Parliament.
No, you couldn't really have sued Parliament when the Attorney General is there.
Parliament.
How can you do that? The Attorney General represents the state. So
no, usually speakers are added to suits.
Yeah.
The court will decide whether they should.
I didn't want to go that way because you go back and then,
I guess he had a specific objective.
So now speaker is not part of the state.
So because it's very difficult to say.
Justice is Attorney General.
It's go down in history as probably one of the best cases. However, please,
final
as Obiama is saying,
it's a bad decision.
It may be a bad decision, which is why I'm considering the possibility of a review. So please, all this encouraging me from MPP and NDC Please, I need more money.
No, really.
I need more
But
money.
bring a bill to Parliament. Parliament should be able to pay you.
All
Because
right.
it's for the national interest. It's a national.
Okay, so gentlemen, thank you very much.
I don't want the 9-0.
I have.
Oh, you have a point.
Yes,
Okay,
I
sorry.
should have a concluding.
Okay,
So
have a
please.
concluding
So
remark.
please.
Sorry, sir.
Let's pursue
I'll give
this
you.
national
With the
agenda.
7-0. So don't worry yourself.
Okay, so thank you very
Let's
much.
pursue the national agenda.
I hear you.
With all the zeal.
Sometimes when they talk this way, they either CPP or PNC.
Luckily, everybody knows I don't belong to any of these, and I continuously belong where I am. I would ensure that I do not take any party card.
Hey, don't say something you may regret later.
I said no. I don't regret. I've said it several times.
So
You've
you
heard it.
decline any appointment from any government?
No, that's not what I said.
That's
Still
different.
national interest. That's still national
join
interest.
it for national interest.
If any party decides that Justice Abdullahi take this position to advance the cause that you're already fighting in your private life, why would I reject it?
Okay.
I'll definitely not reject it.
That's different from being
I will still
a
do it
member of
because-
a political party.
But
Okay.
that's not being a member of a political party.
Okay, so that's different.
Yes.
So, final point to you on this, Honorable Dapiama.
Yet, it's a
Just
very.
to give you time.
He said he had a point to make, so I have to allow him quickly so we can take a break.
It's a sad
Sometimes before
decision
Sometimes because
that-
they tell you have 10 minutes to make
that
your case.
the
This
court
time is
came
more
to the
bad.
conclusion that Order 1053
I still worry you.
offended the Constitution when they haven't demonstrated
He's repeating the same
that
Okay,
it
but you
did.
said that earlier.
Yes,
So-
it's very sad.
Okay, thank you very much, gentlemen. Many thanks to all of you who've been watching with your text messages. Just let me quickly read this one. This one from Mubarak from Sunyang. Good morning, Jifa. I'm not surprised at the Supreme Court ruling because this is the same court that also said that a birth certificate does not determine that you are a Ghanaian. Moses
these
from
things, you should read that.
Treponi says, do the two speakers have the same benefits as their colleagues who are not speakers?
No.
Their additional benefits are their votes, and they must share that with their constituents. And the final message from Master Planner King Tampo says the Supreme Court ruling is apt. The Speaker is not a member of Parliament, but deputy speakers are MPs representing constituencies and have voting rights. Parliamentary standing orders emanated from the Constitution, and parliamentary standing orders are not and cannot supersede the Constitution. Thank you very much for your messages. We take a quick break, and when we come back, we'll deal with Sal.
I'm seeing a lot of messages commending me. Please read them out.